Hi, everybody. I think we'll wait at least maybe just a minute or so that people can start to join. But thanks for joining us on our discussion on immigration compliance for hospitality employees. So we'll just give probably just 30 more seconds to make sure people can get access to this, and then we'll get started. All right. Looks like I see some people coming in, so I think we can probably go ahead and get started. Again, I'd like to thank everyone for joining us here for our discussion on immigration compliance for hospitality employees. My name is Jason Addlestone. I'm an attorney here at Harris Sliwoski. I lead our firm's hospitality practice group in our Denver office. I also have come into law. This is my second career. So I didn't start off as an attorney. I actually started off in the restaurant and hospitality industry, spent 20 years there. Started off as a busboy, host, and ended up running and managing restaurants, both front of house and back of house. And so one of the things that I think is important about this conversation to all talk about throughout this webinar is just that a lot of this information is going to be difficult to hear. But in this increased enforcement environment, we just want to make sure we're providing you with the information you need to be compliant and to protect your employees as much as possible. And while some of this may be difficult for some employees, and especially those that have been with you for sometimes decades, this information is just being presented so that you know what is required, what could potentially happen if you do see ICE enforcement at your hospitality business, or really any business for that matter. And so, like I said, I'll be kind of weaving some stories of my experience kind of in and out to highlight some of these difficulties. But I'd like to introduce Akshat here. He leads our immigration practice group and is out of our Seattle office. And I'll kind of let him speak a bit about it himself and what he does.
Excellent, Jason. Thanks. Thanks for that intro, and thanks everybody for joining. Obviously this is a very timely topic, and there's a lot to cover, but I would, kind of just saying a little bit about what I do. I've been with Harris Sliwoski since 2017. I'm a corporate immigration attorney. Prior to law school, I was a paralegal in the immigration field. I've been around the block for many years, and the importance of compliance has never been greater. I advise clients on a variety of work visas, both non-immigrant and immigrant, and we're going to dive into what the current environment is and how companies can protect themselves.
So I think kind of as we've mentioned, the enforcement risk is on the rise. And I think it's incredibly important to point out the specific legal requirements that can help ensure your business is compliant and will withstand any enforcement action that ICE brings or any notice that they're going to be visiting. And as I mentioned earlier, some of this is going to be difficult because some of this will certainly affect or could possibly affect some of the employees that you've had. I know when I managed restaurants, there were plenty of individuals in, especially my kitchen, kind of the back of house operations, who you didn't know for sure, but it was kind of an understanding that you didn't ask. You kind of assumed that they were legal because they had the documents. But as was the case in a lot of different restaurants, a lot of managers sometimes will just not ask follow-up questions or double check to make sure that the documents are compliant to today's standards. They just kind of rely that they were compliant on prior standards. And that's because, these people, especially if you've been in the restaurant for a long time with them, are like family, and you don't want them to be affected. But what can happen, especially now, is if you don't ask those questions, if you don't follow up to make sure that those documents are what's needed and are properly completed, you could potentially be risking the rest of your employees and your business in general, because today's environment, we have seen such increased enforcement, and the hospitality industry is a real target. And so there are a lot of businesses that are being audited, or ICE is checking on to make sure that the employees are legally able to work there. And so that kind of leads us into the first kind of overview topic. And like, what is the basic rule of thumb, Akshat, for making sure someone is allowed to work in your facility, but especially when someone comes in to start employment? What are kind of the key things that you need to make sure you're focusing on?
Yeah, excuse me, absolutely. It's really important to understand the landscape here. The landscape is that the rules that govern employment authorization have come about as a result of the IRCA of 1986, which is the Immigration Reform and Control Act. It was signed into law by President Reagan, and it essentially said that there should be no unauthorized hires for U.S. employers. And this is something that covers, any worker. So U.S. citizens, green card holders, even if you know that somebody has been, was born in the U.S., you still have to complete verification for their ability to work for you. The responsibility really falls on the employer. It's not the employee's burden, it's the employer's burden to make sure that the forms are complete, that they are properly safeguarded, completed, and from time to time, these audits are needed, internal audits are needed to make sure that there aren't technicalities that expose the company. The penalties, range from a nominal $272 for some aspect of the form that is not completed to something a lot more. And in some cases where there's a pattern and an intention to defraud, criminal charges, including jail time, can also be handed down. So these are serious things. The amounts that are mentioned here are per violation. So, when you have a large workforce, it certainly, multiplies significantly fast. So important thing, the takeaway is that consistency is really important. You may have multiple locations. You need to make sure that the practice is standard across the board. And ideally, there would be, one or two people in the company who are responsible for organizing and making sure that the files and I-9s are up to date.
Yeah, and that's an excellent point, and thanks for highlighting, especially that it's a per instance violation fine. I mean, that's substantial. I know I worked for one of my earlier jobs was for Brinker International. I worked for Macaroni Grill, and Brinker, but at the time they had Macaroni Grill, Chili's, and a whole bunch of other facilities. But they're operating hundreds of restaurants with thousands of employees. And so ensuring that your training is consistent across all of those businesses can help prevent substantial violations. Because if you don't have that consistency, a lot of these locations, especially for a company of that size, could just be incredibly substantial. So one of the most important aspects is also one of the first instances you really connect with an employee. And while a lot of times you can tell that employee, like you have your interview or you let them know that they were hired, you tell them they need to come in on their first day with the proper documentation so you can fill out the form. And so a lot of times they may not come in with that. You do have a very limited amount of time to make sure you get that. But what are some of the key things to focus on when you're reviewing the documents and the kind of identification that these new employees bring in?
Sure. So, let's talk about the Form I-9. That's, as you said, that's where the employee completes the form, chooses one of the List A documents or a List B and List C document. And we're not going to get very granular about, what field needs to be completed or which documents are accurate. For the purpose of this particular webinar, we're looking at the big picture. We're looking at making sure that companies recognize, the industry recognizes what it needs to do, both in terms of best practices and in terms of timeliness. That's really important. So, when a person is hired, you have 3 business days within which they are to complete the I-9. You want to not delay. You want to give them that reminder early on so they can go through what they need to on their end to complete the form. Another important thing to note is that an employer cannot ask for specific documents. It is the employee's responsibility and right to provide the documents, identify which documents are being provided, and if they meet the criteria, then the employer has to accept those documents. In line with that, the completion of the form does require attention to detail. And there are times when employees, in the rush to get started, might not necessarily complete the form. The employer should always check the I-9, particularly when it comes to typos or incomplete fields, because those things get sedimented over time. They get pushed, in some folder. And in the event of an audit, if those are found, then that could lead to those those $272 fines that I mentioned. So it's not just about the right document, it's also about making sure that the I-9 itself has been completed properly. Now, sorry, no, go ahead.
I was going to say, so talking about the right document, what happens if someone hands you a work permit or a document that you're not familiar with? What would you suggest they do at that point?
Yeah, so, they are identifying which document they're providing and why it meets the employment eligibility under either list A or list B and C. Just because something looks foreign, just because it doesn't jive with what you want to see, you can't reject that particular document. And then it dovetails into the E-Verify program, where E-Verify is a program which we're going to talk about a little bit later, but essentially it allows for the employer to upload the documents into the portal, and then the government essentially reviews those documents and then says there was a match or that there was no match. By going through that process, as cumbersome as it may seem initially, what it does is that, I don't want to say that it provides a safe harbor, but it certainly mitigates the risk from the employer side, because now the information has been turned over to the government, and the government is responsible for making sure that the documents are indeed legitimate. And so important point here, of course, is that if it's a foreign document, don't reject it. Rely on what the employee has provided. Don't ask for more secure options, and don't treat foreign nationals differently than you would American workers. There are real implications for the Department of Justice. Their IER division is responsible for enforcing these anti-discrimination laws, and they can also assess fines. They can ask employers to undergo training and even reinstate an employee, or they can award back pay. So the point here is that employer is not going to know the full range of documents that an employee is going to provide, but their job is to make sure that the form is completed correctly, and that the documents don't show obvious inconsistencies.
Yeah, no, great points. And I think that kind of dovetailing with the E-Verify makes a lot of sense, that can provide a bit of protection on the employer's side to just make sure that the documents are legit without possibly rejecting an unfamiliar but valid document that could lead to these discrimination risks that an employer can also face. Because it's not just the risk of ensuring that your employees are legally able to work at your business. It's also ensuring that you don't discriminate against them in their ability to work. So you kind of have to balance both of these and make sure that you're complying with both, which E-Verify at least will provide a little bit of assistance and some, like you said, protection. Doesn't guarantee it. But I know one of the things for me, so when I was managing a restaurant, this was back quite a few years ago, but I was managing in Arizona in this instance that I'm going to speak about. And it was during the time that the state was arguing with the Obama administration on whether or not they could kind of create their own immigration policies and enforcement. And famous Sheriff Joe Arpaio was the sheriff at the time. And his sheriff deputies were really basically just stopping anyone who wasn't white, pretty much. There were tons of stories of this. And I, along with many other managers, again, worked with so many individuals who were especially Hispanic. And a lot of managers would kind of, in order to help protect these individuals, would drive them to and from work. And again, would also potentially not look into the documents that they had originally used. I mean, there were some restaurants have individuals who've worked in restaurants for decades. And what's really difficult is that e-verify kind of, especially in Arizona at this time, became a really big question. Restaurants were being asked to use e-verify. It wasn't required at the time. And a lot of them decided not to because they didn't want to do that extra step that could potentially place an employee in a position where you had to let them go or request documents that they may not have and then let them go. And so it was just kind of avoided. But with this increased enforcement right now, e-verify is becoming a really important tool for hospitality industry, agricultural, really anyone who's really facing these increased enforcements to verify their employees. And while, again, we said there's some difficult things that you may have to face, that may lead to some difficult decisions that have to be made on some employees, but could protect all the other employees you have and your business. So Akshat, how can restaurants use e-verify to the best of their abilities to ensure that they are protecting their business and all the other employees that may not be affected by it?
Yeah, and your experience is definitely not unique, but as you said, um, these are different times, and it's a matter of existence in some ways because the enforcement is going to rise, and I think that it's really important for the industry to recognize that the earlier that they get their house in order, the longer their chances of being able to survive and thrive. The key thing with e-verify is that it is, it's a bit of a hassle. It seems like a bit of a hassle to get started on it, but then once you do, it becomes that much more easier to upload documents and not have to think actively about a ticking time bomb that you have with paper forms that may be sitting somewhere ripe for audit. So again, it has to be for everyone, not just foreign nationals. Have to use it consistently. And then the thing that often we see is that when documents are uploaded into the system, the e-verify system will sometimes issue TNCs. These are tentative non-confirmations. In other words, the system may not recognize a particular document that has been uploaded. And that can happen for a variety of reasons. For some individuals, it's a question of, their work authorization includes photographs that are fairly dated. In other cases, individuals with work authorized capacity who enter the US at the border, their information may not necessarily be in the SSA system. So these TNCs come up often, but there's a prescribed course of action that must be followed. So as soon as the system generates the TNC, the employer has to print out what's called a further action notice. And what that notice does, essentially in a 10-day period, the notice it has to be signed by both the employer and the employee, and the employee has to have a chance to cure. In other words, the employee can say, I have a valid work document. I don't know why this is happening. I'm going to challenge this. So once they challenge, the system will generate another document called referral date confirmation. And that's the document that the employee will need to take with him or her to the Social Security Administration with their actual work authorization. When they go there, the SSA will not see them unless they have the RDC, the referral date confirmation. And once they're able to show their documents, this happens quite frequently, once they're able to show the documents, once they have an I-94, which is a form given to foreign nationals with work authorized status, when they show those documents, SSA is able to update the records. Over time, what has happened is that foreign nationals who enter the United States with immigrant visas, essentially as green card holders, there's data sharing between the State Department and the SSA, which was not the case up until a few years ago. And so as a result of that, if somebody had gotten an immigrant visa and had come to the US a few years back, that system was not in the Social Security Administration database, and that's why the TNC would have been generated. But it's a prescribed procedure. It is very technical, and that's why it's important to have a protocol in place, have, one or two individuals, and then we say two individuals because, turnover happens and you want to have a plan of succession. So you educate someone to do this consistently, and then make sure that there is a backup in case that person's on vacation or is no longer with the business.
Yeah, no, that backup protocol, that's an excellent, excellent recommendation. Having multiple people so that if one leaves, I mean, especially in the hospitality industry, we have such high turnover at times. Having someone who at least that helps protect, to ensure at least one person is able to train another person and to keep that knowledge base there. Because you always want to have someone who's trained and understands not just filling out the proper, say, I-9 forms, everything you need there, but also if you're using E-Verify, if it's required in your state, or if you've just opted into it, that they know how to properly use that as well. So that is an excellent suggestion. So now let's kind of move into what we're seeing or what can happen when you do have different types of enforcement actions or just notices of an inspection. So I think now we're turning to, there are two kind of notice of inspection versus notice of enforcement. Let's starting off with the notice of inspection, because that's going to be the last kind of like breaking down the doors. You have an idea that they're coming, and now you need to make sure, if you, hopefully you've already done this, and we'll talk about this in a minute, but if you haven't already audited your forms, you know that they're in place. Kind of what would you say is the first step someone should take when they receive a notice of inspection, knowing that they really only have 3 days before they're going to have to produce these documents?
Yeah, the number one thing when an NOI is served is that time is of the essence. But it's also important to make sure that all I-9s are gathered. What ICE doesn't want to see is you releasing the I-9s in batches. They don't want that. So that's why the 3-day period is essentially designed to allow companies, allow establishments to gather their I-9s across all locations and then present them to ICE in one batch. Within those 3 days, you also have the ability to correct the I-9s. But I want to talk about, it's really important to make sure that things are not backdated, because if you backdate things, if you use whiteout, that is something that ICE absolutely will not tolerate. So you want to get, if you have the system in place where you have someone who coordinates I-9s, if you haven't done an internal audit, that means that you will need to do that audit pretty quickly. You want to get counsel involved. You want to make sure that people who are familiar with the forms and the technicality of completing the forms are involved, and that they are acting quickly in order to present all of the I-9s in the manner in which, as corrected as they can be to to ICE. If any corrections are made, let's say, for example, there is a typo, it's important to just cross that out, initial and date when that correction was made, and then put in the new information. When ICE sees that, it sees that, of course, the records were rectified, but they weren't falsified. And that's really the key over here. The instinct for some might be to kind of make it seem like it was always the case, that the forms are always correct, but that will come back and bite you in the future. The other thing to keep in mind also is about how much do you disclose. There are times when employment authorization conversations have taken place by email, where an employee completed I-9 and provided a document, but then they're having conversations with their manager about, getting this document or that document. Maybe there's delay, maybe they're traveling. Sometimes in the cases of, non-immigrant visa holders, if their work permit expires, there's a new one on the way, there's a receipt notice, all these things, there aren't really spaces on the I-9 to identify all of these conversations. And so employers sometimes get tempted to reveal that trail of information. but that trail is not really the subject of a notice of inspection. It's just the I-9. So there's a section on the I-9 where you can re-verify employment. If a work authorization, an EAD card, as it's called, expires, then you're supposed to do re-verification when the new card, essentially before the old card expires, you're supposed to re-verify the new card or put in a receipt notice. So there are sections on the form that should have been completed. But when you don't have that, you don't want to include emails and other things that might end up confusing ICE and might make them seem that you are just using it kind of like a parallel system instead of the actual I-9 system.
Yeah, and I think going back to making sure that you have at least one or two people properly trained in this in each location and each business that you have, or is important, because this may be for a particular location, but if it's for all of them, you need to get all of this information gathered together within these 3 days. And if you just have one regional manager, say, that's responsible for all of your stores, that's going to be a nightmare. But if each individual store has their own process for collecting these and for, again, filling them out correctly and having everything in proper places, it's going to make that much easier. You're going to be able to provide ICE with information in a clear and consistent manner that doesn't both frustrate them and possibly provide them with fewer information than they need or more information that they need,
Exactly.
which also can be problematic.
Exactly right.
So I think, so next, moving from just the notice of inspection to a notice of enforcement. And this is where you can sometimes see doors broken down. You can see sometimes if it's a big one and they know they're going to get people, they're going to, ICE could potentially call the media, that they're going to be there. And this is really where I think ensuring that your staff understands that they know what to do and what not to do is important. I know, again, another story from when I was managing. I was managing a back-of-house at this time, and we did have a raid where they arrested 2 of our back-of-house staff. And every restaurant employee knows that, and I use the Department of Health as a perfect example of this. Whenever a health inspector comes in, they always would go to the host stand, and you would have someone quickly run back to the back of house, say the health department is here, like just check, you do kind of this really quick check, make sure everything's okay, kind of put something that might be a major problem, like you fix it right there. But when you have this type of enforcement action in ICE, that can actually put you as the employee or as the manager in a predicament and potentially under criminal penalty, especially what we're seeing now with some of these enforcements where they may think that you're trying to hide someone or trying to do something to kind of prevent their enforcement. And so what should you do? What should employees do? What should manager do if they're faced with an enforcement action or quote unquote raid when someone, when an ICE officer walks into the business?
Yeah, I kind of compare this to, let's say you have a Food Network show where you have, time within which the entree needs to be prepared and the clock is winding down. And when it's time, you see the contestants kind of just back off. And that's essentially the image that I have in mind, where when there's a raid, they're typically acting on either inconsistencies that they have noticed as a pattern, or there have been reports and they have reason to believe that there are more than one employee who's affected by this. And if they see a pattern, they may end up, it might be a false tip, but that doesn't mean that you stand in their way, that you try to direct them into particular parts of the establishment. Your job at that point is to remain calm. And it's important that all employees are aware of this. They're coming in with force, as you said. They're essentially breaking down the doors. So you don't want to interfere, because now you're looking at obstruction as a charge that could be added. And harboring, that's another thing that they do. You're if you tell employees to hide somewhere, now you're harboring aliens, and you don't want to be stuck with a charge of that type, because it's a criminal charge, and the implications are serious. So
just to jump in on that, I think that's to go back to kind of the heartbreaking aspect of all of this right now, is kind of what I mentioned before about managers sometimes driving some of their employees to and from work as a way to possibly protect them from potential enforcement could put them now in risk of enforcement for harboring.
Exactly. Yeah. And that applies to US citizens. I mean, US citizens cannot get deported, but they can face a whole lot of criminal complications. And it's important to recognize, that in this particular enforcement climate, the administration really wants to get at everyone who is working unlawfully. And it is heartbreaking. I mean, I think that the human element of this cannot be ignored, especially in an industry like the hospitality industry, where employees are not just staff, they are your brand. They are the face. And so it's really important to kind of have to come to terms with that. And it is an existential thing, right? I mean, I think that there are restaurants and other businesses that might say, no, we don't want to cooperate, but then their ability to operate as a business is going to diminish significantly over time, because I just don't think that this is going away, and I think that it's going to step up.
Yeah, no, very true. And sorry, I kind of interrupted this
No.
kind of flow through here, but I thought that was just, I mean, again, it's just we can provide you with information. You're doing a great job kind of laying everything out, but it's so hard when you account for the human element of all this. And like you said, they're your brand. Some of them have been with you for, I mean, if you're a restaurant that's been around for decades, some of them have been there the whole time.
Yeah.
And came in before all of this. I think it's 1986, before some of these requirements. And so it's such a difficult thing to be facing, but one that everyone at least needs to have the proper information.
Yes. Yeah. On that note, I know that we got a question about what happens with if somebody is employed before 1986, and it's important to note that you can have employees who've been with you for a long time, and theoretically an I-9 doesn't need to be completed for a person who was hired pre-1986. But it's important to also remember that if there was any break in employment, let's say they took a 3-week break and then they ended up leaving the company, if they came back, then the requirement to do the I-9 is triggered at that point in time. So continuity of employment is super important for somebody who theoretically wouldn't necessarily need I-9 if you look at the original date of hire. However, any cessation in employment, any break in employment could make them subject again to the IRCA, to the I-9 requirement. So it's important to kind of note that oftentimes, at the border, for example, CBP will say, like, people used to have green cards that didn't expire. Green cards never had an expiration date for many, many years. And over time, they started issuing green cards that had a 10-year expiration. Then you renew it after every 10 years. So people who would travel without that green card, with an unexpiring green card, would then be gently reminded by CBP to say, hey, look, we're letting you in now, and your permanent resident status doesn't go away, but go through the effort of getting a green card that has biometrics, that is, that's basically brings you up to speed on the way that things are now. So similar to that, I-9, even for somebody hired before 1986, is not a bad idea, unless you're willfully trying to do that due diligence, which is actually a worse idea.
Yeah, and I think, I mean, that'll bring us into kind of our next discussion. But just to wrap up this kind of enforcement, I think the biggest thing that everyone just, I think, needs to take away from all this, other than just making sure all the other stuff that we're talking about, is just, if you have if ICE comes in for an enforcement action, just don't interfere. Make sure it's a valid warrant. Contact your legal counsel, and just kind of let them do it. Don't try to do what I mentioned before with the health inspector. Don't try to just fix something or move someone out the back door quickly or some. Don't mess with any of that. Just let it happen and then deal with it as it comes. But yeah, so moving forward with kind of what you're talking about on not a bad idea to have I-9s. Obviously, the idea is to not have an enforcement action in the first place. Not have a notice of inspection, but if you do have a notice of inspection, ensure that your documents have been are properly filled out and have been corrected if it was needed. So what are the steps that you would recommend someone take to make sure that their I-9s are done correctly, and if they need fixing, they're done right?
Yeah, this is something that we cannot emphasize enough. Um, Going through these exercises ahead of time in a manner in which you control the hysteria, and it's not even hysteria, you control the process. You're just going through, examining documents, making sure that things are correct, updating things, putting the date that they were updated. All of that is super important to avoid that panic that will result if there's a notice of inspection. And as you know, the key distinction is notice of inspection is administrative. A notice of enforcement action is criminal. And so, given the fines and given the pattern, and depending on the workforce, it's really important to make sure that you are reviewing your paperwork. You're making sure that these things are, are done as a routine matter. It's essentially like brushing teeth. You want to get to the point where it gets done right, and then put away. But then, maybe once a year, I have clients who do this where once a year they will have an audit. They will ask us to conduct the audit, and we will go in and we will review the files, and we will make sure that everything is in order. If not, we will identify that issue, and the employer will then be able to correct it proactively. So not only is it going to prevent or mitigate rather the risk of what fines may be assessed when there is a notice of inspection, but also it will those good faith efforts just show that you are a compliant employer, and that makes you more credible when it comes to if you have 100 I-9s and out of that there are 4 or 5 that are deficient, technically that could result in fines. But it's not unusual for ICE to say, overwhelmingly, you are doing the right thing in a timely manner, you're correcting. So we're going to let you, go. We're not going to assess fines. Just make sure that these things are corrected and you have a plan of action where these things don't occur again. So I think that, from a bottom line, financial bottom line, 100%, it's going to result in fewer fines across the board over the years. And then secondly, prevention is better than cure. If you can take care of these things ahead of time, it also shows your workforce, including those who are responsible for managing the I-9. When things go south, the person or the persons who are responsible for managing I-9s are under the microscope. You don't want to throw them under the bus either. You want to give the opportunity to allow them to, review on a timely basis periodically, so that it's a matter of just, producing the files as opposed to, fearing what could happen.
And how long should companies, or how long are companies required to maintain these I-9s? So
Right.
even if you don't have the employee there, you still you still are required.
Yeah, it's 3 years from the completion. I think we talked about this. It's 3 years from the completion of I-9, or 1 year from the date that the person was terminated, and whichever is later, right? So you want it. Just because the employee is not there anymore doesn't mean that you're off the hook. You want to keep that information accessible in the event that there's inspection at any time in the future,
Yep.
or
Sorry if I
within
missed
one
that.
year.
If you mentioned that
No,
earlier, sorry.
no. You and I had talked about that.
Oh, got it.
When,
Got it. Okay, good. That
no,
makes
we
me
have not.
feel better then.
We have not
Okay.
shared that information, but it's a good point
Yeah,
to
no.
raise.
That's, I think, just an important kind of piece to understand, that you can't just, I mean, if you're going through an audit right after you've terminated someone, you can't just get rid of that. You got to hang on to it for if they've been terminated for at least another year. So,
Exactly.
all right. Well, I think turning to kind of a couple examples and kind of just some discussions. I know we've talked you've mentioned a couple of these briefly, but I thought I'd let you kind of go through these and kind of what people should do if they run into these situations.
Yeah, these 5 things listed there are very common. We see this quite frequently. the first one we've talked about, so I'm not going to go back into it. But there are instances where individuals whose either green cards are lost or their documents have expired, receipts are okay. There's I-9 guidance that says receipt notices for certain types of applications and employment authorization are okay to re-verify the I-9, but that typically is limited only to 90 days. In other words, part of best practice is that without necessarily saying your green card is expiring in 6 months' time, go ahead and start the renewal process. I think it's a good idea for the employer to periodically remind employees that, if you have an employment authorization that is going to expire, just make sure that you keep it valid for, you start the process of extending it. I'll mention that in the case of non-immigrants, if you have, this doesn't really affect the hospitality industry as much, but if you have a work visa such as an H-1B, or there's e-visas, you have you may have a work authorization that's on its face good until, let's say, 2027. However, when they enter the United States, if their passport is expiring next year, then CBP, Customs and Border Protection, will rightly truncate that work authorization to the expiration date of the passport. So you may have a piece of paper that says that the work authorization is valid until 2027, but in reality, that I-94 is going to dictate your employment authorization. And because you effected an entry into the US, now that work authorization has gotten truncated. Most employees, even in more sophisticated employers who are doing this all digitally and keeping track of their files, because it's the employee who travels, the employers are not going back to the employee and asking, check your I-94 to see until what date your employment was authorized. So it's really important to have kind of this blast, maybe quarterly, maybe biannually, to remind employees to check their documents and to do any extensions as and when it's appropriate. Expired passports, that also comes up. Most people don't start the renewal process for the passport until it's very close to time. But most countries will allow for passport renewals 1 year before the passport expires. So important to note that in some cases the receipt notices are okay, but that encouraging that culture of self-check is also very important. Another episode, all right, and I do want to mention that there are instances where what happens after those 90 days, if you have a receipt notice, you have a green card that has expired, you filed an extension, it's taking months and months for these benefits to be approved. If you have a receipt notice, it's been 90 days, then there is a mechanism to go to the USCIS and to get what's called an added stamp. It's on the passport, and it effectively gives work authorization for 1 year as a basis of that stamp. And typically within that time, the new document arrives. If it doesn't, you can go back again and get another stamp. That used to be the case for many years, but now the receipt notices oftentimes will say the validity of the card has been automatically extended by 36 months or by 48 months and so on and so forth. Where it doesn't say that, you have those 90 days and it needs to be fixed within that 90-day period. We talked about this previously when we talked about the non-confirmations. If there's a mismatch, don't terminate the employee immediately. Have them go through the process of taking whatever documents they have, going to the Social Security Administration, and correcting any discrepancy. In some cases, they may not be able to do that, and at that point, that case effectively is terminated or is marked as completed in E-Verify, and you will have to make the hard decision of letting that employee go, because what documents that may have looked good on their face were, if they were not legitimate. So if the employee is unwilling to go and prove that the documents are legitimate, that's a sign that they're not, and you need to find a way to part ways. And the last point there that I want to mention is that even with notices of inspection, it's an administrative um, process, not a criminal process, but an administrative process can lead to investigations, audits, and criminal charges. The same way that, a police officer pulls you over for expired tabs on the highway and then ends up finding contraband in your trunk. Now, because that stop was authorized, and even though it was an administrative stop, at most you would have gotten a ticket for it, or a warning. Now the case becomes, out of control. So what we see is that as a result of these smaller investigations into just I-9 reviews, deeper investigations into payroll issues, tax issues, is the employer underreporting its income? Is there, data privacy concerns where things are not kept in a secure way? What about identity theft? Is it doing the due diligence to make sure that the sensitive information that it has for a lot of employees, is that safeguarded? So it's all the more important to do these internal audits to make sure that the forms are correct, because then it doesn't lead to something more. Where there's smoke, there's fire. And what you want to do is you want to douse the smoke, or you want to, prevent the smoke from arising in the first place.
Yeah, absolutely. And yeah, that it definitely, or not definitely, but it likely just won't stop there. So yeah,
Right.
you don't want to give them reasons to be looking elsewhere in places that they hadn't even thought of. So moving on to the next slide, I think this kind of just before we get to some tools and next steps, I know we've talked about two, especially the top two, and almost every slide that we've had, because they're so important. I mean, just auditing files and training staff, like that just is the key to ensuring that you don't have to worry about these kind of extreme circumstances where you have an enforcement action, or hopefully you don't have to worry about the notice of inspection. But I think these next two are also really important, and just kind of provide a practical avenue to ensure that you have everything that you need and you're prepared once it happens. And so I mean, here you mentioned we have on here practice scenarios and training sessions. I know when I was working in the restaurant, hated those. Really hated anything that involved outside training, coming in on a Saturday morning before the restaurant opens, and having alcohol training, food training, whatever the case may be. This training, though, I mean, it's incredibly important, especially for your management, and can possibly be conveyed to your staff through team meetings before the shift, but especially your management. Practice scenarios are going to be really important. And I'll kind of let you kind of jump in there and also talk about the next one. And
Yeah, no, and I very much value your industry experience, because the insights that you bring talk about, just the prevailing attitude within the industry, because obviously, you're in the business of serving, and so the paperwork is just an afterthought. And so, when we talk about a culture of compliance, the culture of compliance effectively, the way that we stop at a red light at 3 a.m., even if there are no other cars there, we don't think twice about it. Similarly, I think that what we see also the administration wanting to do is to create that culture of compliance where, at the time that you go from not having to worry about it as much to an era where, the enforcement is really high, it is, at the end of it, you want to come out with a plan of action, and you want to be able to make sure that, even if there's turnover, that your practices remain consistent regardless of who is handling them. We talked a little bit about this also, the difference between administrative violations and criminal violations. These are intentional violations. When employees who are, who don't have work authorization are hidden, or the employer goes through a great amount of effort to prevent them from, to say where they're residing and stuff like that. I think that you see this happening a lot more, where the administration leverages whatever strengths it has in order to root out those practices. So not much more to add other than to say that, there's this grace period right now, where if you haven't been audited, then you want to use this time wisely to make sure that your documents are in order, that your staff is educated, that you run through scenarios, that the more you practice something, the more calmness the employees will be able to show when an enforcement action takes place. So yeah, I think I don't want to belabor the point, but I'm happy to hear kind of some additional insights that you may have on this.
No, I mean, I think that's great. I would say that, especially in this situation, I know we would write, or our regional manager would come in and we'd have meetings and write our own SOPs on certain things, or we'd review our own SOPs. So one thing I would say is, if you're a business that doesn't currently have standard operating procedures on this, or haven't audited your I-9s, or maybe just want someone to review your SOPs and your audits, definitely reach out and let us know, because having someone like us, having a professional actually write the SOPs, will help ensure that they're done at least properly, or at least they're all the information that is needed is there. Because I mean, I spent 20 years in the hospitality industry as an employee, having no idea of the real legal aspects of it. It's only now that I represent restaurants that I've actually kind of understand the legal aspects, the employment concerns, and I've been able to take kind of the reality of what I lived with kind of what's going on now, and what would I do as a manager now. I mean, if I had an employee ask me to drive them to and from work because there's a ICE checkpoint somewhere near them, or they knew someone who was arrested, I mean, I would like to think I still would, but that question is a lot more ambiguous. I mean, it's not only risking them, it's risking myself, my family, the restaurant that I would be working for. So, I mean, it's just to go back to kind of, I guess, a theme we've discussed. It's we provide the legal assistance that's kind of the black and white legal, like, this is what you need to do, this is how you do it, and this is how it should be executed. But it's such a different kind of perspective, having come from a time when, I mean, Arizona had real strict enforcement, but I didn't really have to worry about it in this way. I mean, I had to worry that if I did drive someone to and from work, the sheriff might pull us over, but they probably wouldn't do anything to me if that would have happened.
Right.
And so I just yeah, I know we have up here coming up next just some tools and next steps for people, but I do think probably the biggest one is just really having a conversation with your team, and just being real about kind of what's going on, what needs to be paid attention to, and why you're doing it. I mean, just having a manager present an SOP or present a meeting to your staff saying, this is what we need to do, like, we can't help anyone who you think may need help, like if we have an ICE raid, like just telling them that isn't going to make sense, because these are your colleagues, your friends, people you've worked with for a long time. And so I think it's just, in addition to implementing the things we've talked about, making sure you have that conversation with your staff, and allow them to come and talk to you about it. I mean, I think that's really important as well.
Yeah, 100%. I think that, I value your insight, and also the street creds you have, when it comes to clients, kind of recognizing that you come from a background, you know how things work, but these are different times, and it's a matter of survival, effectively. We go through, as you said, we provide guidance to our clients. We will have webinars and in-person trainings where we would talk about, kind of run through different scenarios. looking at the guidance, providing the what is the word I'm looking for? Kind of like a cheat sheet about key things to watch out for. The same way that these things are posted in the office where the managers are, so that they know generally. There's a checklist, for example, of like what to do when a new hire comes in. These are the types of training tools that we provide to our clients, and then we conduct these scenarios and meet with clients from time to time, including doing audits. The idea being that the more that is done as on one Saturday every year, it is that peace of mind that the client is getting for withstanding an audit if it comes their way. I also think that the the takeaway effectively that I will say here is that because hospitality runs on people, by taking these actions ahead of time, involving employees at the administrative level, you are essentially breeding loyalty. And it's counterintuitive to what we have said, which is that you're going to encounter, deficient documentation, and that might lead to some attrition. But what you are also doing is you are showing the rest of the employees that you have their back, that there isn't, this isn't a hanging sword that could come back and fall on them later on. You are trying to remain compliant so that the business of serving food or housing guests or whatever it is that you do in the industry ends up running without interruption. So that's my last thought on this.
Yeah, no, that's a great thought, and thank you so much for providing this overview of the legal requirements, what's needed. I mean, your experience in this space is incredibly helpful, and I know our clients have appreciate it, whether it's in the hospitality or outside of the hospitality industry. Your experience, your background, kind of everything, it just provides a wealth of knowledge and understanding of what's going on. And so thank you for this overview. I've enjoyed this conversation. Again, like I said, having come from the operational side to the legal side, there's a whole new area that I've learned over these past few years on the legal side. And this is just another area that I've been able to dig into in depth with you, and have really appreciated. It's going to be very helpful. I believe we've answered all the questions that we had. So, but if we didn't answer anything, or if I missed any question that wasn't answered, feel free to reach out to either of us. Our contact information's here, and we'd be happy to answer those questions. Or if, like I said earlier, if you're in need of assistance with your SOPs, with providing kind of discussions with your staff, kind of going over everything, we do that, as well as auditing your I-9s, really. If you have any questions about any of that, feel free to reach out to either of us. So thank you very much for joining. I hope you've enjoyed this discussion that we've had. I know I have. And yeah, hopefully we hear from you soon to help you out. And good luck out there.
And I would, nothing else to add. Yeah, thanks for joining. And we are here to help you in any way we can.